Let's talk about before the trial, kind of what happens, as we progress towards the trial. And this gets at this issue of competency, which is a loaded word, right? So we think of the word competency and being incompetent as something that's very negative. But in this strict sense, it was really getting at whether the person is able to go through the trial process. So the landmark case of Dusky versus the United States back in 1960 sets up the first kind of major precedent for establishing the construct of competency, and essentially says that the individual undergoing a trial has to have the capacity to understand the nature and objectives of the court proceedings, including understanding the roles of people in that process. So let's break that down a little bit. They have to have the capacity to understand. They don't have to understand this at the level of an attorney, but they have to have the basic capacity to know what is going on, the nature and objectives of the court proceedings. And if you think about our criminal justice system, right? If you've seen Law and Order, you know how this works, right? There are two equal opposing sides, right? There's the prosecution, there's the defense. We have this adversarial system, and each side is afforded an opportunity to provide evidence. And then the verdict is what's decided on by the trier of fact. The person has to have a basic understanding of those objectives and the nature of how this works. And they have to know what the defense attorney does, what the prosecutor does, what the judge and jury do. And then number two, they have to be able to assist in their defense by consulting counsel. So they got to be able to communicate things to their attorneys. So this is actually a very important aspect of the criminal justice system. And it can be raised by anyone. It can be raised by the judge. It can be raised by the prosecutor. In fact, it could be argued that the prosecution should have just as much motivation to make sure that someone's competent as the defense. But in all reality, this issue is almost always raised by the defense attorney. And the defense attorney raises this issue because they have concerns in meeting with their attorney, with their client, the defendant, right? That this person may not be competent. They may not understand what's going on. It can be raised at any time, okay? So this is not something that is a one and done. In fact, there are cases I've been involved in where the competency has been raised at numerous times, both well before the trial starts and maybe even the week of the trial. And of course, that really upsets the judge because, in essence, that would delay the start of the trial, which judges often don't like to do. But this is an issue that could be raised at any time. And unlike criminal responsibility, which got at how the person was doing at the time of the offense, this issue is a contemporaneous evaluation of their functioning. How are they doing now? The courts have established through a number of precedents the standard for raising the issue of competency. And it's essentially, if anyone has a doubt about the competency of the defendant, if there's any irrational behavior or any major reason, the bar is quite low for raising the issue of competency. It's high for being found incompetent, but the bar is low for triggering a competency evaluation. And then the standard of proof, right? So we think about criminal trials have beyond a reasonable doubt, right? That's the standard that the court uses for establishing culpability in a case. Well, in reaching a decision about whether the defendant is competent, the defense must put on evidence to show incompetence by a preponderance of the evidence, which just means that they have more evidence suggesting that the defendant is incompetent than competent. Dr. Bundy, you had mentioned this earlier, and I think Walt is going to share this with everyone. If I don't know if you're to share with everyone, Walt, or if they have to request it, but this is a really wonderful paper done by the ARC on individuals with intellectual and developmental disabilities in the criminal justice system.
Yeah, you just said it. It's a white paper. It's about 40 pages in length. You can get it from Walt if you just screenshot or get hold of that title, you can search for it, and it's available for you to look at if you want to read more about the issues we've been talking about today.
Yeah. But Dr. Wanda, you want to say a little bit about some of the, like, why this is such a relevant issue for people with developmental disabilities?
We've got a couple of these little pie charts pulled from this white paper, just showing that, between 4 and 10% of adults who are facing criminal charges may qualify for a diagnosis of intellectual disability. So that's how common competency may impact people with developmental disability in the system. Keep going, Dr. Wygant. We've got a few more of these. So then you might say, okay, well, so we have this many people in the system with developmental disabilities. Their competency has been questioned. Were they found incompetent? So this is obviously varies, but somewhere between 12 to 30%, 36% may be determined to be incompetent. And then the white paper goes into how complicated that can be. Can
Right.
competence be restored? I don't know if I'm getting ahead of myself, Dr. Wygant, but
No, you're fine.
if we think about somebody, for example, with a psychotic disorder, restoration of competence could involve a psychotropic medication treatment. The person behaves in a more rational way, and then they're, restored to competency, found competent. If the question related to competency has more to do with abstract thinking abilities, decision-making abilities, vocabulary, as you mentioned, Dr. Wygant,
Right.
then restoration to competency becomes more complicated. And we start to run into a problem, because if a person supposedly, if they're waiting to see if they can be restored to competency, the wait can go on, and usually while they're waiting, they may still be incarcerated. Right. In a situation in which there are no specialized services for somebody with developmental disabilities. So it's really a complicated scenario.
Yeah, that's a great point, a great transition, Dr. Bunny, to what happens if someone is found incompetent. And, I can just tell you what happens in Kentucky, and I know a little bit about some of the other states I've worked in. In Kentucky, the court is mandated by law, if someone is found incompetent, to be reviewed for an involuntary hospitalization or placement in a psychiatric facility, using the first two guidelines that the courts use here in Kentucky, which is Kentucky Revised Statute 202A. That would be involuntary hospitalization for someone who might have a severe mental illness. And then 202B is involuntary hospitalization due to intellectual disability. And then relatively recently, we have a new statute called KRS 202C. And this is for individuals who are found incompetent, who may or may not benefit from treatment, but because of community safety issues, can't be simply released, right? So in some cases, if the individual is found incompetent, the charges are dismissed. In fact, they often are, and then it triggers the 202A or B statute for examining hospitalization. But there was a particular terrible case in Louisville, which I won't get into too many of the specifics of, but essentially what happened is this individual was found incompetent for an offense. He was so psychotic that he was unable to benefit from treatment, which the 202A criteria say that the individual has to benefit from treatment in order to justify being hospitalized involuntarily. That individual was unable to benefit.
And I think in that case, he had been found incompetent on 6 or 7 previous charges, had been hospitalized, showed no improvement in condition. So.
Yeah. But what ended up happening is he was released after being found incompetent and not able to be hospitalized, and committed a very, very serious offense. And so it actually brought up in front of the legislator, like, what do we do with folks who are incompetent, won't benefit from treatment, therefore cannot be hospitalized? And so they came up with 202C as a way of kind of dealing with that situation. And Dr. Bundy, you had mentioned, this kind of back and forth about, is it better to be found incompetent? Is it better to be found competent? And it really depends on so many factors, right? So, I mean, obviously the court wants the defendant to be competent, right? The idea of in our judicial system and process where, you're presumed innocent and we have this adversarial process, the court wants everyone involved to have an understanding of what's going on, the nature and objectives of the proceedings, and to be able to work with their attorneys. But when we're talking about individuals who may have a developmental disability, as we've discussed, there can be a lot of ways in which, those conditions can really impact the person's ability to know what's going on and work with their attorney. And so for those folks, being found incompetent may be a benefit to them. However, as Dr. Bundy said, that can greatly extend the length of court involvement. They could be hospitalized involuntarily. So you're talking about civil liberty issues here. And they may end up remaining in either correctional settings or other settings where they might not have access to the types of treatment they need. So it can be, as the title of our talk implies, this could certainly be a pitfall for people with developmental disabilities.
We have a couple questions here. I think I can address the first one, although knowing you may have something extra smart to add, Dr. Wygant. So the simple question is, how does competency work with individuals who have a full guardianship? Regardless of whether the person is their own guardian or has a guardian, the competency procedures are going to be the same. Certainly, the attorney is likely to bring up whether the person has their own guardianship or not, right? If the person has a conservator or a guardian, it's likely that the attorney will mention that as additional evidence that the person has some special needs. But regardless of guardianship, we're going to take them through some assessment procedures to try to learn about their competency. And then can you see that complicated question about 202B versus C, Dr. Wygant?
Yeah, so Dr. Goodlow's asking about individuals who have been admitted to, what is it, ICF again? I forget.
Intermediate care facility for folks with intellectual disabilities.
Right. So folks admitted to those facilities under 202B, but are better represented with the 202C, will experience a change in the order placing them. I will say, Dr. Goodlow, we don't really know how this is all playing out. Here's what I have seen. I've been involved in a couple cases, none involving folks that have an intellectual disability, but more individuals who have psychotic conditions. And those found incompetent and unrestorable and subject to 202C have all been placed at Kentucky Correctional Psychiatric Facility, which is more known as KCPC. And essentially those folks are staying there and they're evaluated before the court on an annual basis. The one case I was involved in involved a pretty significant case in which the defendant was charged with murder, and it was a particularly violent offense, and he was found incompetent and is remaining there. So I don't know. I think this is so new that we are still figuring out exactly how this is all going to play out. Okay. We're going to speed it along, Dr. Bundy, a little bit since time-wise, making sure we get through as much of this as we can.
We may not make it through everything, but we'll keep going.
So the issues, and I can speed up a little bit. So the issues before competency really break down into two major types. One, the foundational competence, which are minimal standards required for being competent. And we think about things like, does the defendant understand the charges? Do they understand the purpose of the proceedings? Do they understand the adversarial nature? Those things that I've already talked about. Do they have a capacity to appreciate their position, that they're the defendant, they're on trial, they have rights? And can they relate pertinent information to their legal counsel? So can they tell their attorney, this is what happened, this is where I was when the police showed up, this is, and really provide their side of the story. The next phase, though, is, I think, more impacted in individuals with developmental disabilities, which is their decisional competence, meaning, do they have the ability to rationally participate and make the types of decisions that have to be made by defendants in the legal system? Things like the two biggest issues: do I take a plea deal? do I go to trial and testify on my own behalf? And there you really got to think about the reasoning, right? So if you think about that plea bargain, which 99 or around 99% of cases end up with a plea bargain, right? So very few cases go to trial. And when a defendant accepts a plea bargain, they have to plead guilty, and then they have to, hopefully they're getting a better offer. So they're getting a reduced charge or reduced sentence. But in order to make that decision, they have to appreciate the strength of the case against them, which means they understand the evidence. They understand how strong the case is against them, therefore the likelihood of them being found guilty. And then they have to reason that in light of that strength and in light of what the offer is versus if I go to trial and lose, what the potential sentence is. So you can see that there's kind of a higher order reasoning that's required by that. And of course, that's why so many of these types of evaluations involve IQ testing to look at that intellectual ability, as well as achievement and adaptive functioning, and then also autism specific assessments when that's needed. There are two competency specific measures that Dr. Bundy and I have used and that really relate to the types of cases that we're talking about today. One, when looking at juvenile defendants, there was a measure developed by Tom Grizzo in 2005 called the Juvenile Adjudicative Competence Interview, or the JASI, which really relates to the issue of competency from a juvenile perspective. And in the early 90s, I think one of these individuals was a psychologist and one was an attorney, developed a measure called the Competence Assessment for Standing Trial for Defendants with Mental Retardation, more widely known as the CAST-MR, which is the only instrument that has been developed. And again, it's 30 years old, but it's the only one that is explicitly developed for defendants who have an intellectual disability. So I know you've seen this list before. I don't think we need to spend a ton of time going over it. But again, the question for people like Dr. Bundy and I is, how would something like an intellectual disability or autism impact or interfere with the person understanding what's going on in the trial? So I've talked about the reasoning, acquiescence, just going along with whatever the attorney says. We want you to take this deal. Okay, well that involves a major revocation of your rights, and so you have to appreciate what that means. And so you can see information processing. A lot of trials involve complex data that is presented, at pretty high speeds. There's language and verbiage used in the legal system that can be very complex. And so you can see how certainly an intellectual disability could impact the person really understanding and really being able to be a rational participant. Dr. Bundy, you want to say anything quickly about autism and how that might impact competency from what you've seen?
Yeah, the main thing I want to say, I think I mentioned this earlier, but the person may appear to understand everything because of an advanced vocabulary and good reading skills, good decoding skills, when actually the person isn't deeply understanding what they may be able to read something aloud, but they don't have a deep understanding of it. And despite an advanced vocabulary, they may not be understanding the abstract concepts involved in legal procedures. So I think competency may be overestimated in some individuals with ASD.
Yeah, very good point. In Kentucky, our competency standard very much looks like the Dusky standard set in the federal system, which basically says that incompetency to stand trial means as a result of a mental condition, lack of capacity to appreciate the nature and consequences of the proceedings against one or participate rationally in one's own defense. So again, it gets at, does the individual appreciate what's going on and can they participate rationally? And I want to say a little bit about this in a case that I worked on. And actually, this is a case that Dr. Bundy saw much earlier in a clinical capacity. This was a guy who was 36 years old. He was charged with criminal possession of forged instrument, second degree, and persistent felony offender. In this case, the guy was essentially couch surfing. He was essentially homeless, had a long-standing history of intellectual disability. And there were a string of thieves and kind of rogues who came up from Georgia and were seeking people who appeared to be homeless and appeared to have disabilities, to engage in this criminal behavior. And what they did is they found this guy and they basically said, we'd like to hire you as a landscaper. And he got in their car and the guy said, well, before you do the work, we're going to actually pay you. What we need you to go and cash this check. So they wrote a series of checks to him and said, if you cash this $1,000 check, we'll give you $100 or $200. And so what they would do is they would drop him off at the bank. He would go in and they would leave. So if he got caught, they would be gone. And that's in fact what happened. So he did this a number of times and accumulated multiple felonies in both Fayette and Madison County by passing forged checks. And this guy thought that he was being paid up front for the work that he was going to do. As you can see here, I used a fairly extensive battery of psychological tests. And as you can see here, the guy had a long-standing history of intellectual scores that were in the intellectually disabled range. And I just want to point out something. This is when we got involved in this case. And actually, Dr. Bundy's company was approached by, I think, mitigation specialists in this case. Y'all did an IQ test to establish what the attorney at the time was looking for was whether or not he had an intellectual disability. You found that he had an IQ of 45. I was unaware of this when I saw him, and about 3 months or 4 months later, did my own IQ testing. Again, I would not have done this if I had known Dr. Bundy had done this, because as Dr. Bundy teaches in her course, you want to wait, 6 to 12 months.
Mm-hmm.
Yeah,
you don't keep giving that IQ test over and over again.
And of course, what ended up happening is after I found him incompetent in my report, the prosecutor sent him to KCPC, and they also did an IQ test on him, even though they knew that I had done this IQ test. So one of the things that's really important, we talk about this in Dr. Bundy's psychometric IQ class, is that repeated testing can absolutely inflate scores. And if you look here, within 1 year, we show an increase of almost 15 points, which is one full standard deviation on the WACE. So it just reillustrates that point that we got to be careful with these tests. So in this particular case, what I found was that this guy had a moderate intellectual disability. He did not fully appreciate what was going on. He could not make rational decisions about should he take a plea deal, given that he was caught at the at the bank. They caught him, the saying red-handed, right? They caught him red-handed. And he did end up making statements to the police. Those statements were used against him. He could not really appreciate the potential sentence if he was going to go to trial and lose versus take a plea deal. He kept getting hung up on the fact that they told him if you did one type of charge, he would have to serve 85% of the sentence. And if he took the plea deal, he would only have to serve 20% of the sentence. This guy just completely lacked the ability to calculate in his own mind and make sense of in his own mind what that would mean. If he was to take this and get this amount of years, but only have to serve 20%, or this amount of years and serve 20 to 85%, he just couldn't make any sense of that. He did not fully appreciate what was going on in terms of what the prosecutor was trying to do when they were asking questions and what they were trying to do in the case. So I wrote a report, and I actually testified both in Fayette County and in Madison County because he, on the same day, went to banks across the river. And I thought that he was incompetent. But I will tell you, the bar is quite high, and he was found competent to stand trial in both counties. And I remember the attorney telling me when we left the courtroom, he said, Dr. Wygant, I think competency or incompetency is effectively dead in Madison County, because if this guy was found competent, how could anyone be found incompetent? And it's a wake-up call, right? I mean, even though you have what I thought was this guy had significant limitations for going through this process, the court disagreed, and ultimately that's something that can happen. So, well, we're going to wrap up with kind of the last part of the process, which is what happens before the sentencing. And this can get at two different topics: mitigation of penalty and risk assessment. And while some defendants may not be found insane, meaning they don't meet the criteria explicitly for an insanity defense, there are still ways for the court to investigate whether or not they're fully culpable in terms of their penalty. So this is, in the clearest sense, referred to as an extreme emotional disturbance. So did the person engage in behavior under the influence of such extreme emotions, maybe not a mental condition like schizophrenia, but such an emotional state of mind that they would not be guilty of the highest offense? The classic example would be, a man comes home, finds his wife, with another man, and shoots them both. And but for that situation, this would never have happened, but he was so enraged and taken by the emotions that it occurred. That's probably the clearest example of an extreme emotional disturbance, but there are other ways in which the courts can look at both direct and indirect influences. And so one of the questions I've been asked many times, and Dr. Bonner, you probably have too, is, because the person had autism spectrum disorder or an intellectual disability, even though they displayed some appreciation of the wrongfulness, could you at least say how that condition may still have impacted their decision making? And so that can still be considered either for negotiating a better plea arrangement with the prosecution, or is presented before the judge pre-sentencing so that the court can at least appreciate those things. And things that we're talking about would be things like trauma history, intellectual impairments, developmental disabilities, substance addiction. And then courts should, I'm not saying they always do this, but should look at the vulnerability of the defendants in terms of sentencing them with respect to their mental state. So judges should consider whether putting someone with an intellectual disability in a correctional setting, or autism spectrum disorder in a correctional setting, what the impact of that might be, and whether or not a more treatment related outcome might be better. The next kind of aspect involved in this is what's called risk assessment. And this is where the court asked for some assistance in thinking through how much of a risk would it be for this person to be in the community under something like probation, let's say, versus a more strict incarceration. And so the psychologist who does this, or psychiatrist, they can look at these types of factors in making that determination. So, it's hard to predict the future. I think any psychologist would be foolish to say that we can absolutely predict who's going to be violent or not. But there are a number of factors that the literature has established in terms of elevating one's risk for future violence or sexual acting out. And there are static factors, obviously gender, age, arrest history, delinquency, previous behaviors can play into this. But then there are more dynamic current factors that have to be considered as well. So active symptoms of mental illness, substance use, kind of a negative emotional state, particularly anger, antisocial attitudes, negative attitudes towards treatment or supervision. Obviously, weapons access becomes an important decision. Really, though, the last part is where psychologists can kind of get back to that advocacy role, because what we can think of as what are protective factors that we can put into place that could mitigate someone's risk for violence. For example, are there services that we can recommend? Are there kind of other factors we can put in place that would reduce the likelihood of the person engaging in violence? And really, this risk management approach is one that kind of guides the current thinking in this field. And I want to end with kind of a case example. We got to be quick with this, Dr. Bundy, because we're running out of time. But this is a case that we both worked on and we really enjoyed working on, I think, last summer. This is a guy, a 47-year-old male, who, if you look here, these kind of look like long charges, but essentially these are federal charges stemming from him sending a letter to a public official. I won't say who, but let's just say a very important public official at both the state and federal level, maybe the executive level, right? Sent letters to them, basically threatening them. And in one of the letters, writing the word anthrax and including in the envelope shavings of a soap bar that may look like anthrax. Obviously a very serious charge. And I will add, he did this while in prison serving a sentence for writing bad checks.
I know my suggestion was no more white soap available in the prison. Could you just use a green Irish Spring? So it won't be as easy to shave it into white pieces.
So I did this.
They didn't take me seriously there.
Yeah. So I did this mitigation evaluation for his defense attorney. And when I saw him, I did an MMPI, which is a personality task that indicated some potential psychotic, things going on that ultimately resulted in me thinking that this guy had a schizotypal personality disorder, which is on the schizophrenia spectrum. But then I also got kind of a sense fairly quickly that this guy may be on the autism spectrum, which is when I called my good friend here and said, please help me out in this case. And so Dr. Bundy got involved and completed an interview with me with her sister, with this guy's sister, the autism diagnostic interview revised, and then also did the ADOS-2 in the jail with me that really supported both an autism spectrum disorder diagnosis and the schizotypal diagnosis. But Dr. Bundy, you want to say a little bit about this guy? We felt that there wasn't an insanity defense because he did know what he was doing, but help us understand the link between his behavior that we just talked about and these developmental disability symptoms.
Well, one thing that was a wonderful resource in this case is that we had this sister who could provide very rational and detailed, developmental history. What we found that from the age of 10 years of age, he was already interested in writing letters, frustrated letters to public officials. This was really obsessive interest and almost leisure interest for him to learn, to watch the news, to find out about political figures, and to write letters. So this is behavior he's been engaging in all his life, really not with the intent of malice, but out of his own interest and sort of political knowledge and special interest. Even in jail, he had a very rigid routine, and part of it involved getting up very early and watching the news every morning so he could follow what the political events of the day were. He became very
military. Remember the military interests?
Not only interested in, but extremely knowledgeable about military history, even though he had
weapons.
He didn't have a very high educational attainment, but he could talk in great detail about some factual kinds of information. So you can see how we ended up looking at an autism spectrum disorder. He had, obsessive thoughts about these political figures, and then would engage in compulsive behaviors, including letter writing. And similar to the person that we talked about earlier today, he said, I never wanted to hurt anybody. I knew it wasn't anthrax, but I just wanted to get the person's attention, and I didn't know how else to do it. This person, never wrote me back, right? From an autistic perspective, I wrote a letter, it was very polite, and I never received an answer. I'm going to have to escalate my letter writing behavior to see if the person will respond.
He had some complaints about how he was being treated in the prison, wanted to air these grievances that he felt were not being addressed. So he wanted to get the federal authorities involved to come and investigate the matter. They didn't, and that's what Dr. Bundy's talking about here.
That's right. So he wasn't wrong. He probably had received some mistreatment. It was very frustrating to him that nobody would listen. And at the same time, just to sort of give you the perspective on some of these people, this guy, can write perfectly well. He has a lot of facts about some information. On the other hand, he has a lot of social misunderstanding and naivete. He has also a special interest in some cartoon characters and has some fantasies about particular cartoon characters helping him. And he asks his sister to send him little t-shirts that have the cartoon characters on them, right? So he's a really complex figure that is not well represented by the list of charges that Dr. Wygant showed you when we first started talking about this case.
Ultimately, we were able to make a compelling argument in front of the judge, and the federal judge in this case gave him the minimum sentence and ran it concurrent with the remainder of his state time. So he really didn't incur any additional sentencing. And the attorney noted that our report was extremely helpful in making that happen. So, well, guys, we're at the end here, and we just have some concluding remarks. Dr. Bundy, you want to say anything about these remarks, or would you like me to?
Well, sure. Individuals with developmental disabilities may be overrepresented in criminal justice and forensic settings. I referred to this earlier. I think they may be also over-incarcerated related to nonviolent offenses. Dr. Wygant really did a great job of taking us through the different stages of the criminal justice system, which you may not have been able to deconstruct before, and show you how forensic psychologists may work at those stages, how individuals with developmental special needs may be impacted at all of those stages. And it's just important for self-advocates, advocates, family members, attorneys, judges, right? Law enforcement officers to be mindful of the possible presence of people with these special needs in the criminal justice process, and what some of their rights and special needs might be. I think I saw a question, it didn't come in through Q&A, but it came in through chat. Basically, the person was just pointing out how important they thought it was for law enforcement officers and judges to be aware of these needs and how some of these problems could arise when people with developmental disabilities end up involved in criminal proceedings.
Well, guys, I think that's it for us. I've left Dr. Bundy and I's my contact information here. Walt, if you're okay, can we stay on a little bit and answer some of these questions? Is that all right with you?
Absolutely.
Okay.
Absolutely.
I'm going to stop sharing, and then it looks like some of them are in the chat, and some of them, I don't know that the Q&A was really used a lot. So can you help us out here by going through some of these comments here?
Well,
I was just going to say, customized cars.
Whoops, I'm pulling up Patty's she has this suggested YouTube video.
Charge from Liberty Mutual. I customize everything. Like Marco's backpack.
Sorry, guys.
So Liberty Mutual, you can customize and only pay for what you need.
What I was trying to do before I lost the link, I was trying to pull up Patty's 10 rules for dealing with the police. Thank you, Patty, for recommending that. Several of us may be getting some ads as we try to check out that YouTube video. She was just saying that for her son, it's been a simple and educational video to help him, just to try to educate him in a preventive way to keep him from getting into trouble with law enforcement. Right. Thanks, Patty.
We do have a question in the chat, and the question is, how can we make more law enforcement and judicial officials understand these impairments when dealing with individuals with autism spectrum disorder?
It's a great question, and it's a big challenge. Judges are very busy, and I think it really relies on defense attorneys to bring these issues up and really argue them in a compelling fashion in the court. And that involves, getting people that have some training and being able to look at these issues. There are, continuing legal ed, workshops and those sorts of things. Judges, I think, want to be educated about these matters. It's really just making trainings like this actually, and open to judges, and getting the word out, I think is a big part of it.
And I was just going to say, Dr. Wigan and I recently, each of us testified separately in a competency hearing. And it was this wonderful judge with a lot of curiosity. Remember that, Dr. Wigan? Asked a lot of a question. I mean, questioned really, each of us were in there for an hour, really going deep and trying to figure out what was the fair thing to do for the defendant, and just trying to understand as much as they could about these issues. So there are judges out there who are interested in these issues and trying to learn about them and trying to make very careful decisions.
Yeah.
It looks like Patty has just put the 10 rules in the chat.
Thank you, Patty. This is great.
We have one question in the Q&A, and is there an evaluation? And yes, there is. Evaluation will be sent to your email address immediately at the end of this webinar.
Okay.
That is all the questions so far.
All right.
Thanks, everyone.
Thank you.
I would like to thank you for an informative presentation. Thank you both for taking time out of your day to share your experiences and expertise with us. Be well, stay safe. Thank you.
Bye, everyone.